judgment in the appeal, the Queen against Gull.
This appeal is concerned with the definition of terrorism in the Terrorism Act 2000. Mr. Gull was convicted by a jury of disseminating publications which encouraged the commission, preparation or instigation of acts of terrorism contrary to Section 2 of the Terrorism Act 2006, and he was sentenced to 5 years in prison. Terrorism is defined in Section 1 of the Terrorism Act 2000 as the use or threat of action inside or outside the United Kingdom, and I quote, A, involving serious violence against a person, involving serious damage to property, endangering another person's life, creating a serious risk to public health or safety. B, designed to influence a government or intergovernmental organisation or to intimidate the public or a section of the public. And C, made for the purpose of advancing a political, religious, racial or ideological cause. The publications in question included videos posted on YouTube showing attacks by Al-Qaeda and the Taliban and others on military targets in Chechnya and on coalition forces in Iraq and in Afghanistan, and the use of improvised explosive devices against coalition forces. These videos were accompanied by commentaries praising the bravery and martyrdom of those carrying out the attacks and encouraging others to emulate them. The Court of Appeal refused Mr. Gull's appeal. His appeal to the Supreme Court was based on the contention that both domestic law and international law required the statutory definition of terrorism to be interpreted narrowly so as to exclude actions by non-state armed troops attacking foreign armed forces in their territory. The Supreme Court unanimously dismisses Mr. Gull's appeal for reasons contained in a judgment given by Lord Judge and myself, with whom the other members of the court, Lady Hale, the Deputy President, Lord Hope, Lord Mance, Lord Judge, Lord Kerr and Lord Reid, agree. So far as purely domestic law is concerned, the natural and very wide meaning of the definition of terrorism in Section 1 of the 2000 Act cannot be read restrictively, as Mr. Gull argued. The definition was drafted in deliberately wide terms to take account of the various forms terrorism might take and the changes which may occur in the diplomatic and political spheres. However, Section 17 of the 2000 Act, which prohibits the prosecution of most offences under the 2000 and 2006 Acts without the consent of the Director of Public Prosecutions, or in some cases the Attorney General, is of no assistance in this connection. Having said that, the Court observes that creating an offence with a very broad reach and then invoking prosecutorial discretion as a means of mitigation is undesirable in principle and should only be adopted in legislation where it is unavoidable. Accordingly, the only ground for interpreting the definition more restrictively, as Mr. Gull argues, would be if it conflicted with the UK's obligations in international law for terrorism to have such a wide meaning. The first aspect of Mr. Gull's argument in that connection was that the UK's international obligations require it to define terrorism more narrowly in its criminal laws, as it should have the same meaning as it has in international law. The second aspect of his argument was that the UK could not criminalise terrorism abroad, except insofar as international law allowed. Both aspects of this international law argument face the insuperable obstacle that there is no accepted definition of terrorism in international law. A UN working group reported in 2012 that there were disagreements as to the precise distinction between terrorism and what it called legitimate struggle of peoples fighting in the exercise of their right to self-determination. And there is no plain or consistent approach to the meaning of terrorism in UN conventions on the issue. There are UN resolutions referring to the activities of Al-Qaeda and the Taliban as terrorism, although their actions involved insurgents attacking forces of states and intergovernmental organisations in non-international armed conflict. And international law of armed conflict does not give rise to any immunity for combatants in non-international armed conflicts. Further, while some provisions of the 2000 and 2006 Acts give effect to treaties that do not extend to insurgent attacks on military forces in non-international armed conflicts, the UK can go further in the 2000 Act than the treaties go. It's also relevant for present purposes whether the UK can criminalise certain actions committed abroad, because the material in this case was disseminated in the United Kingdom. Finally, the Court notes that although the issue is one for Parliament to decide, the current definition of terrorism is what we've called concerningly wide. The 2000 and 2006 Acts also grant substantial intrusive powers to the police and to immigration officers, which depend upon what appears to be a very broad discretion on their part. To bestow such wide, even intrusive powers in connection with terrorism is understandable, but the fact that the powers are so unrestricted in the context of such a wide definition of terrorism is probably of even more concern than the prosecutorial discretion to which the Acts give rise.